Welcome, everyone. I'm Ben, and today I'm taking you into the story of the mysterious tragedy of 4-year-old Arya Talathi and the shocking case involving pediatrician Neha Gupta, an incident that occurred in the early hours of the 27th of June, 2025, at an Airbnb rental in El Portal, Florida, USA, set against the backdrop of what was meant to be a peaceful vacation, overshadowed by a tense child custody battle, with the central figure being Neha Gupta, a pediatrician from Oklahoma, accused of causing her daughter's death and staging the scene to appear like a drowning. Let's uncover the full story together. And if this is your first time here, I'd greatly appreciate it if you could give a like and subscribe to the channel. It's 3:40 a.m., the hour when most stories are quiet. A sliding door stands open to a backyard pool, black water, still reflecting a rented home that isn't theirs. A mother calls for help, a voice cracking in the dark, and first responders sprint past patio chairs, and a child's towel crumpled like a flag after a storm. Minutes later, in the fluorescent hum of an ER, the clock stops at 4:28 a.m. A 4-year-old is gone. By sunrise, a simple story takes shape. A vacation, a locked door, a child who slipped outside, a drowning no one saw. It is the kind of narrative we accept because it asks nothing more from us than sympathy. But the body keeps its own records. Lungs that should be wet are dry. A stomach that should remember dinner is empty. Inside the mouth, trauma that resists easy explanations. The pool, suddenly, looks less like a scene, more like a stage. Detectives follow the quiet details. A custody battle simmering far from the waterline. A mother who leaves Florida. An arrest caught on body-worn cameras 1,000 miles away. In court, the word is murder, a charge that speaks of intent, of planning, of a moment when thought hardens into action. Then, in a turn that rattles even seasoned lawyers, the word changes. Aggravated manslaughter of a child. Not intention negligence. Not a plan, a failure. So which story holds? The medical examiner's language smothering, not drowning points one way. The prosecutors filing a downgrade that opens the door to bond points another. Somewhere between a silent pool and a paper-thin timeline lies the truth about what happened in the hours after midnight, about a door that shouldn't have opened, a rescue that didn't, a child whose last minutes were not what they seemed. We are going back to that house, to the kitchen clock, the bed sheets, the glass door track, to see what the water can't tell us. Because if the pool was a stage, the question is simple and brutal. Who wrote the scene, and why? El Portal, Florida, a small village wedged between Miami's bustle and the salt air drifting in from Biscayne Bay. It's the kind of place you might pick for a quiet reset. In June 2025, that's exactly what Dr. Neha Gupta did, or so it seemed. A pediatrician from Oklahoma, she booked an Airbnb here, bringing her 4-year-old daughter, Arya Talathi, for what looked like a mother-daughter trip. No father, no extended family, just the two of them. Arya was, by all accounts, a bright, spirited child, curious eyes, a gap-toothed smile. She split her life between two worlds, her father's home and her mother's. That arrangement was the product of a joint custody order in Oklahoma, an arrangement already fraying. Friends described her as talkative, with an affection for swimming, despite her tender age. But her life was not untouched by conflict. Court filings showed her parents were locked in an escalating custody battle. Just months before the trip, an Oklahoma judge had awarded Arya's father temporary sole custody, citing concerns over Gupta's behavior, including alleged interference with medical care and volatile interactions with providers. Neha Gupta's professional life painted a different picture. In Oklahoma, she was known as a competent pediatrician, someone entrusted with the care of other people's children. Her resume carried the weight of training, experience, and trust. But her personal life told a more complicated story, one that spilled into courtrooms and case files. Her ex-husband's petitions described mood swings, erratic conduct, and strained relationships with nearly everyone involved in Arya's care. He sought a psychological evaluation, claiming it was crucial to ensure their daughter's safety. In Florida, there were no colleagues, no family friends, just a rented home, a backyard pool, and a glass sliding door. Gupta would later tell police she had checked that door before bed, that she and Arya fell asleep in the same bed, and that she awoke around 3:20 a.m. to find the child gone. Her account a frantic search, the sight of her daughter submerged, the inability to swim would be the foundation of her defense. She claimed she tried for 10 minutes to pull Arya out before calling 911. To investigators, the contradictions began to stack early. The autopsy reported no water in Arya's lungs or stomach, suggesting she had not drowned. There were injuries inside her, mouth cuts and bruising, that the medical examiner said were inconsistent with CPR. The preliminary conclusion, death by smothering. For law enforcement, that conclusion shifted the narrative from accident to homicide. Yet in August 2025, prosecutors walked back the murder charge, replacing it with aggravated manslaughter of a child, a legal reclassification that signaled either a gap in proof, a strategic pivot, or both. For the defense, it was an opening. They could admit tragedy without conceding intent. At the heart of this profile is contrast a doctor sworn to protect children, a mother accused of ending her own child's life, a vacation house meant for rest, recast as a crime scene. Whether Neha Gupta was a parent pushed beyond her limits, a negligent caretaker, or something darker, remains the central question. And the next layer of this story lies not in who they were, but in what happened, hour by hour, inside that Airbnb on the 27th of June. Next, the night in question, and the evidence that turned a mother's account into a homicide investigation. The 26th of June, 2025, a Thursday evening, the last day Arya Talathi would be seen alive outside the narrow frame of a crime scene photograph. According to Neha Gupta, she and her daughter had dinner around 9 p.m. at the Airbnb in El Portal, Florida. The rental was a modest, single-story home with a fenced backyard, a patio, and a rectangular pool deep enough that a small child could vanish below the surface without a ripple. That night, Gupta said she checked the sliding glass doors before bed, making sure they were locked. She and Arya shared the same bed. In her account to police, the next thing she remembered was waking around 3:20 a.m. to find her daughter gone. She claimed the sliding door was somehow open. Outside, she saw Arya submerged in the pool. Gupta told investigators she couldn't swim. She said she tried for roughly 10 minutes to pull her child out before calling 911 at 3:40 a.m. First responders arrived quickly. They found the glass door open, the pool still, and Arya unresponsive at the deep end. Miami-Dade Fire Rescue pulled her from the water, initiating CPR as they rushed her to Jackson Memorial Hospital. At 4:28 a.m., despite all efforts, Arya was pronounced dead. If the story had ended there, it would have been recorded as a tragic accident, the kind of summer night horror every parent fears. But 2 days later, the Miami-Dade medical examiner's preliminary report cracked that version open. Arya's lungs and stomach were dry, no sign of drowning. Inside her mouth, there were small cuts and bruising along the inner cheeks. According to Dr. Emma Tran, the examiner, those injuries weren't the kind typically caused by resuscitation attempts. They were, however, consistent with smothering a hand or object pressed over the mouth and nose. And there was more. The child's stomach was empty. The absence of food contradicted Gupta's claim about dinner at 9 p.m., raising questions about the accuracy or honesty of her timeline. The arrest warrant detailed these findings, citing them as grounds for charging Gupta with first-degree murder. The theory, in stark terms, was that Arya had been killed before being placed in the pool, and that the scene had been staged to mimic a drowning. From there, investigators began retracing Gupta's steps. She had traveled to Florida without telling Arya's father, Dr. Arya Talathi, with whom she shared custody. According to Talathi, he had no idea his daughter had even left Oklahoma. In fact, just months earlier, a judge had awarded him temporary sole custody after finding that Gupta interfered with Arya's medical care and engaged in erratic behavior. The court ordered her to provide vaccination records and disclose her location orders she allegedly ignored. After Arya's death, Gupta returned to Oklahoma. On the 2nd of July, U.S. Marshals and local law enforcement executed an arrest warrant at her home. Body camera footage shows officers entering room by room, eventually finding her hiding inside. Prosecutors framed her absence from Florida and her location during arrest as evidence of consciousness of guilt. But even with these details, the case was not straightforward. Gupta maintained that she had not harmed her child intentionally, that Arya must have somehow gotten out and fallen into the pool while she slept. Her defense called the police investigation a rush to judgment. The case reached a turning point on the 7th of August, 2025. In a move that startled observers, prosecutors dropped the first-degree murder charge, replacing it with aggravated manslaughter of a child, a charge that does not require proof of intent to kill. The decision sent ripples through legal circles. If the autopsy suggested smothering, why step back from a homicide charge? One possibility, legal analysts noted, was proof. Smothering cases are notoriously difficult to prosecute. The signs can be subtle, the timeline murky, and the absence of eyewitnesses leaves room for doubt. Another theory was that the downgrade allowed prosecutors to pursue a conviction on a charge more likely to stick, rather than risk losing a high-profile murder trial. Still, the medical examiner's findings remain a stubborn contradiction. If Arya did not drown, if she was dead before entering the water, then the pool was not a hazard, it was a stage. And staging suggests intent. The defense, however, seized on the inconsistency between the ME's report and the new charge, arguing that the state's own evidence undermined a theory of intentional killing. What happened in the hours between bedtime and 3:20 a.m. is the axis on which the entire case turns. Did Arya wake up and wander out, unnoticed? Did something happen inside the bedroom that ended her life before she ever reached the pool? Did Gupta panic, making choices that transformed a preventable tragedy into a criminal case? The answers, if they exist, will be drawn from fragments: the lock mechanism on a sliding door, the depth of a pool, the marks on a child's face, the contents of a stomach. Each piece could support either version of events, depending on the lens through which it is viewed. For now, the official record holds two truths in tension: a mother who says her child drowned, and a medical report that says she did not. Between them lies a gap wide enough for reasonable doubt, or for something far more deliberate. And as the case moves forward, the focus shifts from the quiet of that Florida night to the noise of a courtroom, where both stories will be told, and where one will have to survive the scrutiny of cross-examination. Next, how investigators built their case, and why prosecutors chose to scale it back before trial. From the moment Arya Talathi's body left the backyard of that El Portal rental, the investigation began moving on parallel tracks: the medical examiner's lab in Miami-Dade and the detectives' work on the ground in Florida and Oklahoma. Each path would produce pieces of a puzzle that seemed, at first, to fit together cleanly and then began to fray. The autopsy results were the first fracture. 2 days after Arya's death, Dr. Emma Tran ruled out drowning as the cause, noting dry lungs and stomach and identifying cuts and bruising inside the child's mouth inconsistent with CPR. Her preliminary opinion, smothering. That conclusion prompted the Miami-Dade State Attorney's Office to greenlight a murder charge under Florida Statute 782.04, first degree, premeditated. The theory was blunt. Arya was killed before being placed in the pool, and the scene was staged to conceal the true cause of death. Detectives moved to solidify the timeline. Gupta told them she checked the sliding doors before bed, slept beside Arya, woke at 3:20 a.m., saw the door open, and found her daughter in the pool. But they found discrepancies. The stomach contents didn't match her claim of a 9 p.m. dinner. The father, Dr. Arya Talathi, said he hadn't been told Arya was in Florida at all. Court records confirmed there was an ongoing custody battle, and that months earlier, a judge had awarded him temporary sole custody after citing Gupta's interference with medical treatment and erratic behavior. The warrant also noted Gupta's return to Oklahoma after the death, a move prosecutors later characterized as leaving the jurisdiction. On the 2nd of July, the U.S. Marshals executed an arrest warrant at her Oklahoma home. Body camera footage showed tactical officers clearing the house room by room, eventually finding Gupta hiding inside. For the state, this became a key detail: circumstantial evidence of what they called consciousness of guilt. Investigators built a case around 3 pillars: forensic evidence, dry lungs, mouth trauma, circumstantial evidence, custody dispute, travel without notice to the father, leaving the state, and behavioral evidence, failure to swim to retrieve the child, alleged hiding during arrest. On paper, the alignment pointed toward an intentional act, but in August 2025, the trajectory shifted. At a hearing on the 7th of August, prosecutors announced they were dropping the murder charge and filing aggravated manslaughter of a child, instead a first-degree felony under Florida law that focuses on culpable negligence rather than intent. The downgrade was seismic. In one stroke, the legal frame moved from premeditation to gross negligence. Why? Publicly, the state attorney's office said the new charge was appropriate, based on the evidence presently available. Behind that statement, analysts speculated on prosecutorial calculus, proving smothering beyond a reasonable doubt can be difficult, particularly without direct witnesses or unassailable forensic certainty. A manslaughter charge, while still serious, allows for conviction on proof that the defendant's reckless actions or inactions caused the death, even without intent. For the defense, this was an opening. Gupta's attorney, Michael Meyer, repeated his position. She did not intentionally harm Arya. It was a tragic accident. Law enforcement rushed to judgment. The downgrade seemed to validate, at least in part, their argument that the state could not meet the burden for murder. Still, the medical examiner's findings remained in the record and in tension with the new charge. To the prosecution, the injuries could be presented as consistent with negligence, perhaps from flawed rescue attempts or mishandling. To the defense, the downgrade was evidence the state no longer believed its own theory of an intentional killing. The next step would be a bond, hearing something that had been impossible under the original murder charge. Scheduled for the following Monday, it would determine whether Gupta could await trial outside the walls of the Miami-Dade jail. Prosecutors were expected to oppose, citing her prior departure from the jurisdiction and her location during arrest. The defense would counter that she had invested in counsel and intended to fight the case. Whatever the judge decided, the shift in charges ensured the coming trial, if it reached that point, would be a battle over definition. Was this the tragic byproduct of gross negligence, or a deliberate act softened by a tactical prosecutorial retreat? Next, inside the courtroom, where the legal downgrade collides with the raw details of the medical report, and where both sides will gamble on what a jury is willing to believe. The courtroom in Miami-Dade was smaller than the case's headlines suggested: fluorescent lights, wood-paneled walls, and a scattering of padded benches. Yet the air was thick with anticipation. This was the first time jurors, if the case made it that far, would hear the story not as a set of police reports, but as competing narratives crafted for persuasion. On one side, the prosecution table carried the weight of the medical examiner's report, the 911 timeline, and the custody history. They began with the stark facts. Arya Talathi's lungs were dry, her stomach empty, her mouth injured in ways inconsistent with CPR. The state's opening line was precise. This child was dead before she touched that water. Prosecutors conceded the charge was manslaughter, not murder, but urged the jury to see it as more than mere carelessness, a pattern of reckless disregard that ended in death. They walked the jury through the night. 9 p.m., dinners claimed by Gupta, contrasted with an empty stomach. The locked sliding doors, allegedly secured, now inexplicably open. The 3:20 a.m. discovery. The 10-minute delay before calling 911. The inability or refusal to enter the pool despite a child's life at stake. They displayed photographs of the Airbnb layout, the patio, the pool. They called Dr. Emma Tran to explain the autopsy findings, her conclusion that drowning could be ruled out, and the significance of the oral injuries. The defense, in contrast, built their case on doubt. They reminded jurors that the burden was entirely on the state. They charged her with murder. Defense attorney Michael Meyer said, "And now they say it's negligence. Ask yourselves why." They leaned on the idea of a tragic accident, a child who wandered, a mother who woke too late, a desperate rescue hampered by her inability to swim. They suggested alternative explanations for the injuries: accidental self-biting during distress, or mishandling by rescuers. They challenged the timing implied by stomach contents, noting digestion rates vary. The custody battle, they argued, was a distraction, a smear to paint Gupta as unstable. Being in a dispute does not make you a killer, Meyer told the court. They attacked the consciousness of guilt theory, tied to her return to Oklahoma and the circumstances of her arrest, framing it as fear and confusion rather than evasion. Throughout the proceedings, the prosecution's challenge was threading the needle, proving culpable negligence without a clear, provable act of intent. The defense's challenge was to humanize Gupta without opening the door to damaging cross-examination. Whether she would testify was a strategic cliffhanger in itself. Witness testimony rippled with tension. The lead detective admitted under cross-examination that no fingerprints or DNA definitively tied Gupta to a smothering act. A paramedic acknowledged that certain CPR techniques could, in rare cases, cause minor oral injuries, but Dr. Tran stood firm. In her opinion, Arya's body told a story inconsistent with drowning. The atmosphere in the room was taut during the playback of Gupta's 911 call. The sound of her voice urgent, strained, insisting she could not swim played against the still images of a pool just steps from the bedroom. Jurors watched her body language on arrest footage, debated in whispers whether it reflected guilt or shock. The state closed by painting a picture of preventable death. Negligence isn't just forgetting, the prosecutor said. It's seeing the risk and doing nothing. It's a locked door left unsecured. It's 10 minutes spent watching a child die instead of breaking that water. The defense closed with the same refrain they had used since the charge changed. They cannot tell you exactly what happened in that house. And if they can't, you must find her not guilty. Both sides knew the verdict would hinge on the jury's comfort with uncertainty. Was the absence of water in Arya's lungs a smoking gun or an unexplained anomaly? Was the open door a tragic accident or a staged scene? The answers lay not in the science alone, but in which story felt truer when the lights in that courtroom went dark. Next, stepping away from the witness stand, we'll dissect Neha Gupta's profile through the lens of criminal psychology and the law to see what patterns or red flags emerge. To understand a case like this, you have to strip away the courtroom choreography and look at the human dynamics underneath. Neha Gupta was, on paper, a contradiction. A pediatrician trained to safeguard children's health, now accused, however, the charge is framed of causing her own child's death. That paradox alone is a powerful cognitive dissonance for jurors, and for investigators, it is fertile ground for motive analysis. The custody battle is the most obvious stressor in her background. Months before the Florida trip, an Oklahoma judge had awarded temporary sole custody of Arya to her father, citing Gupta's interference with medical care and erratic behavior. Court filings described mood swings, conflict with caregivers, and the spreading of disputed claims about domestic violence. From a forensic psychology standpoint, such patterns can indicate instability, impaired judgment, or a tendency toward controlling behavior, especially when they intersect with high-stakes parental disputes. The choice to take Arya to Florida without notifying the father could be read two ways. The defense frames it as a mother exercising her parenting time, however tenuous. The prosecution frames it as a deliberate circumvention of legal orders, potentially escalating to a defiance of boundaries that might carry over into dangerous situations. If a parent feels cornered in a custody dispute, the pressure can amplify feelings of desperation or entitlement, leading to risky or irrational decisions. In terms of behavioral red flags, the inability or refusal to enter the pool to retrieve Arya despite the life or death urgency stands out. To some jurors, this may appear as evidence of emotional detachment or avoidance. To others, a simple phobia or genuine incapacity. Psychologically, high-stress emergencies tend to strip responses down to instinct. A parent's failure to act in the most primal protective way can be perceived rightly or wrongly as indicative of culpability. The medical examiner's findings complicate any purely accidental narrative. Smothering, unlike drowning, is an active method of asphyxiation that requires proximity, pressure, and sustained action. From a psychological profiling standpoint, it often appears in cases where the perpetrator has a personal connection to the victim, a method that is intimate, direct, and, in a dark way, controlled. If prosecutors believe this occurred, It suggests a potential alignment with a caregiver-driven homicide profile, sometimes linked to revenge against another parent or a distorted perception of protection. Legally, the downgrade from murder to aggravated manslaughter shifts the psychological reading. Instead of proving intent, a deliberate choice to kill the state now must prove culpable negligence, essentially extreme recklessness. Negligence, in this context, could stem from a personality profile marked by impulsivity, poor risk assessment, and tunnel vision under stress. Those traits, in combination with a contentious custody battle, could create a fertile ground for tragic outcomes without premeditation. Forensic psychology also considers post-event behavior. Returning to Oklahoma, then being found hiding during arrest, can be interpreted as consciousness of guilt or as a panic-driven flight response. People under acute stress sometimes engage in avoidance behavior, even when they believe themselves innocent, driven by fear of legal consequences or mistrust of the system. From the defense perspective, Gupta's profile could be reframed entirely. A stressed but loving parent, overwhelmed by personal and legal pressures, caught in a tragedy she could not prevent. From the prosecution's perspective, the same facts could illustrate a volatile personality, prone to defiance and control, whose negligence, or worse, was the final link in a chain of escalating conflicts. In the end, the psychological portrait is less a singular diagnosis than a set of overlapping patterns. A high-conflict custody environment, disputed medical decision-making, emotional volatility, and contested crisis behavior. Whether those patterns amount to criminal negligence or something darker will depend on which version of Neha Gupta's mind the jury is willing to believe. Next, beyond the trial, we look at the ripples this case sends into public opinion, the law, and the lasting legacy for everyone involved. When the charge against Neha Gupta shifted from first-degree murder to aggravated manslaughter, the courtroom wasn't the only place where the tone changed. Outside, in the churn of headlines and social media, the downgrade sparked a split reaction. Some saw it as a pragmatic legal move, a recognition that proving intent beyond a reasonable doubt in a smothering case is notoriously difficult. Others saw it as a failure of justice, a retreat in the face of a child's death that deserved the harshest possible reckoning. In Oklahoma, the custody case was effectively overtaken by the criminal proceedings. Arya's father, Dr. Arya Talathi, became a figure of quiet public sympathy. While he refrained from lengthy public statements, court documents and his cooperation with investigators painted him as blindsided by the trip to Florida and devastated by its outcome. In Florida, victim advocates called for closer scrutiny of out-of-state custody disputes, particularly when one parent travels without notifying the other. On parenting forums and true crime channels, the debate was sharper. Some commenters focused on the forensic evidence, dry lungs, oral injuries, and argued the downgrade made no sense. Others fixated on the idea of culpable negligence, debating whether a parent who leaves a sliding door unsecured or who fails to act decisively in a rescue could be guilty of manslaughter without any intent to harm. The legal community, too, dissected the decision. Prosecutors, speaking off record to reporters, noted that a conviction on a lesser charge can carry substantial penalties while avoiding the all-or-nothing gamble of a murder trial. Defense attorneys elsewhere saw it as an implicit concession, one that could be leveraged in jury selection to sow doubt about the state's theory. Meanwhile, Gupta remained in custody pending her bond hearing. The outcome of that hearing would determine whether she faced trial from behind bars or from home under strict conditions. For those watching, her release or continued detention would serve as an unofficial barometer of how the court viewed her flight risk and potential danger to the community. The case also reignited a broader conversation about how the justice system treats parents accused of harming their children. High-profile examples in recent years have shown a tendency toward aggressive initial charges that later soften as evidence is weighed. For some, that reflects a healthy legal process. For others, it feels like a systemic reluctance to pursue the most serious accountability when the accused is a mother. Whatever the verdict, the legacy of this case will be defined not only by the trial's outcome, but by the way it was fought in courtrooms, in custody filings, and in the court of public opinion. For Arya, there will be no appeals, no retrial, For everyone else, the arguments over what happened that night in El Portal will echo long after the gavel falls. From this case, we see more than just a shocking criminal trial. It's a powerful reminder of how fragile life is and of the absolute responsibility that comes with being a parent. A sliding door left open just a few inches. A few minutes of hesitation, those can forever change a child's fate. In moments of crisis, our actions or inaction can mean the difference between life and death. The story of little Arya Talathi raises tough questions. Where is the line between an accident and criminal negligence? Does the justice system always find a fair answer? And for us, watching from the outside, what lessons can we take to better protect our own children? Sometimes tragedy doesn't come from a malicious plan, but from mistakes, carelessness, or decisions made in the heat of overwhelming pressure. Yet no matter the cause, the loss is irreversible. I want to hear your thoughts. Do you believe this was a tragic accident or an intentional act? Was the decision to downgrade the charge from murder to manslaughter the right call? Share your opinion in the comments below. This story isn't just about investigating a death, it's about how we, as a society, define justice, accountability, and the duty we owe to those who depend on us most.